Therefore, the appeal board overturned all of the rulings of the appeal committee, so with the result that the medical scheme did no longer have to make a direct payment to the service provider. It had already paid its members, it had discharged all of its obligations, and the necessary upshot of that all is that if the service provider can prove that it rendered services to those members, then the service provider is entitled to recover what would be regarded as unjust enrichment from those members. Now, the important kind of lessons and implications of this ruling are, firstly, it's important for medical schemes to define what constitutes a claim in their rules. It's also important for schemes to be clear that where arrangements are entertained which go beyond claims, that the scheme is not bound to those arrangements. Alternatively, if a scheme does enter into a contractual arrangement with the service provider to honour its claims, then it must be very clear what the circumstances are in which it will honour and will not honour those requests for payment, that's not called claims, and also the circumstances in which the scheme is obliged or entitled to cancel that arrangement. A service provider, another important outcome of the ruling, is that a service provider cannot claim on behalf of a member, strictly speaking. A service provider can only claim against the medical scheme if it has a contract which permits such a claim. Otherwise, it's the member's claim against the medical scheme. Either the member can say to the medical scheme, you must pay me, or the member, if that right is available in the rules, can say to the medical scheme, you've undertaken to me to pay the service provider in certain circumstances. Here are those circumstances. Please make that payment. The importance of the appeal board ruling is what the appeal committee had effectively done is, this was the concern of the scheme, it had exposed the scheme to potential fraudulent or collusive or irregular claims, because the scheme wouldn't be in a position to terminate these arrangements, these alternative commercial arrangements with service providers, even if it had good reason to suspect that. So what the Medical Schemes Board ruling has achieved, it has given a level of protection to medical schemes, and in the result, protection to medical scheme members against fraudulent claiming patterns. This is very important in the context of an industry where recently the ethical tariffs on doctor billing have been scrapped. The question of cost in relation to prescribed minimum benefits is held by the registrar's office to include invoice or face value, not tariff-related costs, and there is no longer a national reference price list. So all of the mechanisms that have been in place to provide some protection to schemes and members have really to a large extent been eroded, and there's a lot of flux in the industry, and for that reason this is an important ruling. The interesting question that arises is what this ruling will mean for the standing, or the locus standi as it's held, as it's called in the legal fraternity. What is the position of a service provider to lodge a complaint against a medical scheme, as opposed to the position of a medical scheme member to lodge a complaint against the medical scheme? The appeal board didn't rule on this point. It wasn't a point that was in issue, but it is clearly a question that arises given the appeal board's very clear setting out of the contractual relationship between the member, the service provider, and the medical scheme. So if anybody is interested in seeing the full transcript of this ruling, it does appear on the website of the Council for Medical Schemes, which is www.medicalschemes.co.za.